Good afternoon, members. Welcome to this webinar on liquidation process under IBC to cover the important aspects, developments, and challenges in the liquidation process. This webinar is organized by Committee on Insolvency and Bankruptcy Code of ICI. We have with us our chairman of the committee, CA Gyanchandra Mishra ji, and the speaker for the session, CA Advocate Nipun Singhvi ji, and the moderator for the session, CA Rahul Jindal ji. Welcome to you, sirs. I would request our chairman, sir, to please address the members on this very important occasion. Over to you, sir.
So much thank you, Rita Madam. Very respected speaker of today's program, Advocate C. Nipun Singhvi ji, moderator C. Rahul Jindal ji, and of course, Secretary who is dedicated for the committee round the clock, Rita Madam, and respected participants. Good afternoon to one and all. Friends, we all know that IBC code has become one of the most reformist code and act in last 1 decade. And not only the reform, but we have witnessed value addition in the entire ecosystem of the restructuring. And liquidation is one of the very important process out of the insolvency process. If the things are not resolved, certainly the last thing what we have in our hand, that is liquidation. And to understand the concept of liquidation and various provision, we have arranged today's program, and wonderful speaker Nipunji is with us. Friends, we all know that in the recent times, we see the speed of the economy. Hence, it is bound to be some restructuring process in the economic arena. In last 6 years of the code, we have witnessed that in comparison to the other methodology of restructuring, insolvency has been one of the major area which has given relief to the various stakeholders of the business organizations, especially the bankers, the financial creditors. They have gained a sort of benefit with respect to the realization of assets in recent years. So friends, liquidation is very important aspect which is emerging out of the restructuring and of course the insolvency. And we will understand today from scratch to the entire process from Nipunji. We keep on organizing such webinars on weekly basis. Recently, we had witnessed one very wonderful program of Rizal 2023 in Singapore. And in coming time, a lot of more new events are being planned by the committee. We are also planning to have a complete technical guide about the insolvency and bankruptcy code. And for that, Rita Madam is working very hard. We'll request the members who have joined and of course the speakers and moderators to kindly contribute in the same, not only as in the contribution with respect to the technical guide, but contribution as speaker, paper writing, or moderator, whatever you can do best for the committee. Committee though new, but we are trying to do the best. Lot of suggestions and white papers are being released from time to time to the Honorable IBBI, NCLT, and other stakeholders like MCA as well. Roundtable, discussions and other things have happened in last 15-20 days on various issues being referred by IBBI. Again, we'll request to the members who are interested to take part in reformist positions and reformist arena of the code. They please come forward. They are most welcome. Friends, IBC 2.0 is around the corner. We can expect, if not in this year, certainly in 2024. And some of the major areas like cross-border transaction, group insolvency, and pre-packed insolvency, their modus operandi, their value addition in the system, is on the card. So professional opportunities are probably immense. And in continuation to that, and in addition to that, we are trying to have more and more program and certificate course by which the members can take the benefit to qualify the examination as well as to have better area of practice in coming time. I'll not take much time as Nipunji is here and Rahulji is curiously waiting to start the session. I welcome one and all from core of our heart, and please keep on joining the program because contribution of each one, whether as committee member or as moderator or as speaker, is equally important for the participants because participants are the soul of any program. So welcome you all once again. Thank you, Rita Madam, for your dedicated efforts for organizing such programs in the interest of the insolvency professionals and of course the liquidators at large. And we shall keep on doing more program in coming time. And one last thing that I would like to tell you that we have started one monthly newsletter that is being published on monthly basis virtually. So will request Rita Madam to kindly take suggestion of the members, articles, write-ups, so that we can give the best as possible to the members at large. So much thank you each and everyone for patiently listening.
Thank you, Chairman Sir, for sharing your valuable insights and thoughts with us, sir, and highlighting the importance of this very important code, the IBC code, in the entire resolution process in the country. And you also highlighted the various important initiatives which this committee under your leadership and guidance, which we are undertaking this year, some of which you mentioned like this newsletter and the roundtable discussions which we do on various IBBI or MCA whenever they bring discussion paper or consultation paper. Thanks indeed to you, sir. With your guidance, we are doing this kind of programs for the benefit of members and stakeholders. So with your permission, sir, I will take this opportunity to introduce formally our speaker, Nipun Singhvi ji, and the moderator, Rahul Jindal ji. CA Nipun Singhvi is a fellow member of ICI and a practicing advocate. He possesses educational qualification of CS, LLB, LLM, Certified Forensic IFRS Bank Auditor, Qualified Independent Director from Ministry of Corporate Affairs, Executive Program on Merger and Acquisition from IIM Ahmedabad, and is Qualified Insolvency Examination 2. He has been a member of World Bank Insolvency Group on Train the Trainers jointly with IBBI and IP of all the three institutes. He has delivered more than 1,600 lectures on various laws. He's a regular faculty at ICI, ICICI, Nationalized Bank, C&AG, Trade Association, etc., and regular author of various corporate and tax journals. I would like to introduce now CA Rahul Jindal. He is a qualified FCA, LLB, insolvency professional, DISA certified fraud examiner, certified forensic auditor, IBBI registered valuer, certified concurrent auditor. He is a forensic audit expert and has handled forensic audits for public sector banks, private sector banks, BSE, and other financial institutions. He has taken sessions and seminars for various institutions. So I would request Rahul Jindal ji to please share with us your initial thoughts before we hand over the session to Nipun ji. Over to Rahul ji.
Good afternoon, everyone. First and foremost, I would like to thank Gyanchand Mishra ji, the chairman of Committee on Insolvency and Bankruptcy Code. Since he's himself an RP, I guess he's the best person to lead this committee. He's himself handling many home buyers cases. So the home buyers cases are the most technical one. I guess when Nipun Singhvi ji will take up the matters, we'll come to know that what issues come during the home buyer cases. Should we have a time, Gyan sir would have himself explained what are the issues in home buyer cases. So not going to much of detail. So I welcome Nipun Singhvi ji. All our participants waiting for your deliberation liquidation, since liquidation process has come under certain changes as per the latest guidelines. Now certain change regarding replaced, whether RP can continue as a liquidator, So various changes are being made to increase the transparency level in the insolvency process. Now it is being made more of a time-bound process. Further, some issues are there with the NCLT things, with the court thing regarding the admission or regarding an admission as a liquidation process or approval as a liquidation. So all those issues will be addressed by our speaker, Sir Nipun Singhvi. So, so is my voice breaking, sir?
Yes, sir. So,
Your voice is breaking, Rahul.
Am I audible now?
You can just off your video and then speak, because sometimes video is taking bandwidth.
So I guess this is one of the most growing committees that I'm being involved with, because insolvency is a very upcoming field. As Gyan sir had said regarding personal insolvency, PIRP, prepaid insolvency, cross-border insolvency. In today's scenario, only companies are allowed to be admitted as an insolvency, but we are seeing that individual and it is not far away that the individual and partnership firms will also be allowed to be admitted under insolvency. Earlier, the cases admitted were large. They were because the limit was 1 lakh. Now the limit is 1 crore. So we expect that more and more cases to be admitted under insolvency, and the work will grow either as a resolution professional or as a liquidator itself. So since there are many changes that have happened during the liquidation process, so now Nipunji is here. He will explain you clause by clause in every circulars or the latest amendments that have happened in the liquidation process. So I would request Rita ma'am to take over, and then we can start hearing the all the details and deliberations by Nipun sir. Thank you.
Thank you, Rahulji, for your initial remarks. Now I'd request Nipunji to please start with your deliberations on the topic, sir. Over to you, sir.
Thank you, Rita ma'am. Thank you, Mishra ji, for inviting me. And I am also thankful to the committee, because I think Mishra ji has invited me almost 3 to 4 times now. And Mishra ji, being an RP, is also actively involved in day-to-day affairs. And Rita ma'am, I think that we meet almost every second week with some lecture on the IBC or on. And I'm so fortunate that Institute has been giving me opportunity every now and then. I still remember when I had been assisting this parliamentary committee members when this IBC was in draft stage. I tell you that we never thought in 2015 that this law will come in 2016. Because at that point of time, even the NCLT, when the Law of Companies Act was passed in 2013, was not notified till June 16. So even when the NCLTs were not there, thinking something which was not even dreamt of. So it is very nice that now NCLTs have taken over, and also now IBC cases are given importance rather than Companies Act matters, for which actually the NCLT was born. So this law, and I would say, and thanks to our then Finance Minister, Mr. Jaitley, who had been tracking this law, and I tell you from 2016, this law has been amended almost every quarter or maybe every 6 months by way of an ordinance or by way of an amendment act, being swept through the parliament easily. And it has been market-driven law. So this law is not something which is just made and kept in the cold storage. It has been actively amended, actively modified, and also taken into consideration the market-driving forces. In fact, here I would say that as a regulator, even the IBBI has been very vibrant. They have been coming with clarification, with amendments, with circulars, whatnot. And I think our institute and mostly the larger members of the insolvency professional fraternity are majority from our institute's IPA. So that is also an important aspect, that this particular profession now of IP has been a full-fledged profession. So all these things have helped a lot, and a chartered accountant who knows the accounts, the figures, also knows about the business, has been given an immense, I would say, responsibility and power to bring some resolution of a distressed company. And this is a profession, I would say, which helps us to do something which is an entrepreneurship skill or spirit, which probably, I think, that being in the profession of a chartered accountant, it is very easy for us to think of how does a businessman do the business. So saying this all, what has happened nowadays is this law is just, I would say, 6-year old or 6-year old baby. It's still developing. It's in the nascent stage. Whereas in first 3 or 4 years, we were grappling with the CIRP processes and challenges. During the process of insolvency, have gone into the second phase, that is the liquidation. And liquidation regulations have played a very important role, and they have tried to separate the role of a resolution professional and a liquidator. So even though the insolvency professional, who is supposed to be a person who brings revival or a resolution to the company or makes efforts with the help of the financial creditors to bring about a revival, in case the company is not able to revive, the another option is of trying to revive it under liquidation. So today our agenda would be to discuss about the liquidation process, how it starts, what are the challenges, and what are the recent amendments. And when I say recent amendments, I am talking about last 12 months. Broadly speaking, at least a year, there have been various clarifications, amendments, and view taken by the NCLTs, sometimes NCLAT, and very few cases have reached Supreme Court as far as liquidation is concerned. So as a liquidator, we have to be much more responsible, because during the process of CIRP, our role of RP is not as that of an adjudicator. We are only concerned for collation of claims and verification of claims, but we are not an adjudicator of claim. Whereas when we are a liquidator, we are an adjudicator. And whenever we accept or reject a claim, it becomes an order. And that order can be appealed before the adjudicating authority under Section 42. So the role and responsibility of a RP and that of a liquidator is absolutely different. And recently, so though that reasoning I do not agree, however, there is a guidance given by IBBI that the RP should not be appointed as a liquidator because the roles are different. I do not 100% agree with the reasoning that the RP was not able to bring a resolution or his efforts were less, therefore he should not be a liquidator. There could be cases where even best of the RPs cannot bring a resolution. There could be cases, but yes, the role and responsibility, the power and duties of an RP and a liquidator are completely different. Though they must be having some trappings here and there, but the adjudicator role as a liquidator is much more important. And we have seen a difference from the way the regulator thought of liquidator at the first instance, and subsequently when the thought process changed because of non-transparency of the process of liquidation. Previously, the liquidator was not required to take any advice or approval from the committee. The committee normally was the same as that of COC. Thereafter, law came and they capped the number of committee members in the liquidation. And that's the SCC, Stakeholder Consultation Committee. Again, if you see the law from beginning, SCC was never there. And I still remember one of the case I was handling, which went up till Supreme Court. During the liquidation, there was no guidance on what to do. We had to sell the assets and we have to distribute the money. And when this matter went up to Supreme Court, and I was also representing the liquidator at that point of time, we suggested to the then court, and court readily accepted our advice of making a sale cum monitoring committee. So that was in the case of Citrus Check-in and Royal Twinkle Star Club. These two companies were combined and the Supreme Court accepted the advice of making it a sale cum monitoring committee, and there were 3 representatives suggested. However, court then gave an advice of adding one more representative, and there were 4 representatives in the committee. So point I'm trying to derive is that during the process of liquidation, first the onus was completely on liquidator. He had a free hand. Then it became little bit regulated by such court orders where the committee was made. Thereafter, this concept of committee got imbibed in the regulation, and then came the concept of stakeholder consultation committee. Thereafter, the stakeholder consultation committee constitution came into picture, and the constitution capped the number of SCC members, like from government, department, promoter side, employee side, workman side, all these different representative of different class were there in SCC. Thereafter, now, again that cap has been removed, and now SCC definition has been widely worded. And I tell you honestly, and I would be discussing some of the IBBI disciplinary committee matters, wherein it has been held that if you do not discuss in SCC, or if you do not constitute SCC perfectly according to the regulation, then sorry, there would be disciplinary action against the liquidator. So the regulator is now focusing on liquidation process in a much more serious manner, when it was previously the liquidator was thought of given a free hand. He could have taken any action, any decision, and that could only be challenged in the court. However, now the liquidator is required to consult committee. However, he can have a different opinion from that consultation committee opinion, but that particular opinion will have to be filed with the IBBI and NCLT, and I suppose within 4 days. They have prescribed a format also. So that means that the liquidator now does not have a free hand, or I would say there is a double check by the regulator as well as with the NCLT. So now the process is very serious. So giving some idea about what is happening, let us go through the amendments, how these amendments are now impacting us. And with the amendments, I would also touch upon some of the recent judgments. So I'm just trying to touch upon how this logic of liquidation comes in, how this logic of reviving the company under liquidation comes in. Now, previously, the first matter which went up till Supreme Court was Gujarat NRE Coke, wherein a scheme of compromise and arrangement was given in the liquidation process. Question was, the law was not permitting any such type of scheme of compromise or arrangement. But after Gujarat NRE Coke judgment of Honorable NC LAT, IBBI amended the regulation, and a specific clause, specific I would say, so section regulation 2B was inserted just to say that the compromise or arrangement can also be done in the liquidation process. Now, this process of CIRP already captured compromise or arrangement during the process of resolution plan. So resolution plan definition included, by way of an explanation and a clarification, I would say, subsequently, that a scheme of merger demerger could also be given under resolution plan. But the same concept was not there in the liquidation. But after the judgment of Gujarat NRE Coke, I think Arun Chaktampa, that judgment was there. After this amendment was brought in, and it was permitted to bring a compromise and arrangement scheme under Companies Act during liquidation process. Now, the same thing was also there in the erstwhile Companies Act when the companies were going for winding up. So section 391 to 394 of the erstwhile Companies Act 1956 had a similar provision that you could bring a scheme of compromise or arrangement. And I tell you, very interesting case was, and that applies to IBC also now, because that was in the erstwhile Companies Act. what happened was that the scheme of compromise or arrangement during the process of winding up could be brought by member or creditor. They could bring a scheme, give it to liquidator. The question which arose in one of the matters was, can a third party bring a scheme? So suppose I am a third party, I want to bring a scheme. I want to strike a deal with the creditors and shareholders. And that time shareholders, members, or you could say contributory under winding up act. Whether a scheme could be brought by a third party, and there's a very interesting order of NCLAT in the matter of Amar Daikam, wherein it was held that even a third party can bring a scheme. So this particular matter pertains to Mumbai, wherein NCLT Mumbai rejected the scheme given by a third party. However, NCLAT reversed the order and held that even a third party can bring a scheme. And it is not only the liquidator who can approach with the scheme or who has to approach tribunal with the scheme. Even a third party can approach, and he can approach to the liquidator, and liquidator will in turn file it. So in this particular case, liquidator did not accept the scheme as it was by a third party. However, court rejected that argument, allowed it. Now what is happening is, now there is an amendment in the CIRP regulation where they have specifically brought this amendment to bring a resolution when you are going for liquidation. Parallelly, you have to also get a resolution done by the COC that there would be a compromise or arrangement exploration. So if I want to explore compromise or arrangement, even when my liquidation application is pending, I can very well do it by calling COC, and such a resolution will have to be passed when I am passing a resolution for liquidation. So regulation 39BA is now in the CIRP regulation, though it pertains to something which you are going to do when there is a liquidation going to be ordered, but you can in between, because when the liquidation application is pending, it is not the end of the story. So during this process, when the liquidation order is not there, application is so the point is that this particular resolution now helps us to even explore the intermittent period. Now I would just connect it. What does the regulation 2B says when it comes to liquidation regulation? So I've just not put it in the slide. I'm just reading it out. Compromise or arrangement under 230 shall be completed within 90 days of the order of liquidation, provided that a person who is not eligible under the code to submit a plan shall not be a party to such compromise or arrangement. So what regulation 2B of liquidation is saying, that you have to now here the word is completed. Now this is a very catchy word. The words used are completed. So to bring about a scheme of compromise or arrangement within 90 days is very important, because the regulation says so. Now suppose somebody comes to you with a scheme beyond 90 days. You will have to go to court and get an approval if you want to consider it. Whether court approves it, normally court will approve it, and there are judgments by NCLAT wherein it has been held that this 90 days is only directory and not mandatory. However, as a officer of the court, if beyond 90 days somebody is coming, then we will definitely have to approach the court to get a permission. We cannot go just by this order that it is directory in nature, so we will not follow the regulation. Second is, if somebody is disqualified under 29A, whether that person will be permitted under 230? Sorry, that person will not be permitted. So 29A check, which was there in CIRP, the same check is there in the liquidation regulation. So both are same. Now the question comes, if suppose somebody comes beyond 90 days, let's say in one of the matters where I appeared, almost after 8 or 10 months of the liquidation and in fighting and appeals and all, Promoter said that now I want to come with a scheme because I want to go for OTS, and there was only sole banker. Now under 230, and as probably you must be aware that under Companies Act, to get a scheme approved, you need to have consent of 75% of the secured creditor. Now here, two things are important. When we are talking about CIRP or liquidation, normally the voting is of 66%. However, when you go to Companies Act, this goes to 75%. Also, the words used in the Companies Act are secured creditors. Now, secured creditor definition is not applicable, which we apply in IBC. So that is going to be a catch that under Companies Act, who are secured creditor, you are actually going for a higher threshold. And there is no classification of operational creditors and financial creditors as far as Companies Act is concerned. So there are conflicting judgments on this aspect. The law is, as of now, in my view, is not settled whether we can go by the definition of section 53 or we will have to go by the understanding under Companies Act. So under Companies Act, there have been judgment, whoever is a secured creditor, and normally banks are secured creditor, whether by way of first charge, second charge, or whatever charge it is, that the 75% will have to consent for taking the company under the process of scheme of compromise or arrangement. Now, normally in liquidation, if the scheme of compromise is coming and we are ready to pay them more than, pay the financial creditors who are normally the secured creditors, then they will willingly allow. But the problem is that 66% issue and 75% issue could be tough if there is infighting amongst the secured creditors. And as we know, there has been ambiguity created by the Rainbow Paper judgment with regard to the definition of secured creditors, which is again before Honorable Apex Court. Let's see what Honorable Apex Court decides in the review petition. But the law as it stands today, secured creditor can also be an operational creditor. So again, my view is that scheme of compromise or arrangement as envisaged under the Companies Act will have to pass through a higher muster than through the 66% voting, which normally SCC would allow otherwise. Another important aspect which I think should be discussed is with regard to sale of company. So I'll come on to the schedule 1 and how it says, but sale of company as a going concern, normally people prefer through a scheme of compromise or arrangement, but the conflict comes when the scheme of compromise or arrangement has to be closed within 90 days. So without taking a specific approval by the Honorable Tribunal, we may not be able to extend this period of 90 days. We'll just come on to, I will just cover this. Okay. So now I will come on to the liquidator fee and the recent clarification given by the Insolvency Board with regard to the liquidator fee. So as we all know that the liquidator fee, if it is not decided by the COC, erstwhile COC, then it was being governed by the regulation number 4. And then regulation number 4 gives you a table how the payment will have to be made. Now, the issues which were coming in this particular aspect were whether once a liquidator appointed will continue till eternity. So answer is no. If somebody was going to the court, they had genuine differences with the liquidator, or there could be some issues with regard to conduct of the process, courts were accepting and removing or replacing the liquidator. However, now the regulation specifically provides that the liquidator can be changed, liquidator fee can be fixed by the SCC. So in a way, I would say this empowers the liquidator's fee and the continuation to be sought by the committee members. Now, the committee members in the SCC will have all the rights to allow a liquidator to continue or to change the liquidator if they are not happy with the conduct or the working of the liquidator. Now, the problem which is normally seen in liquidator fee is, so it's like there is going to be a conflict, because from the liquidator's perspective, the liquidator fee is fixed on, as per the regulation, on the amount which he would realize and the amount he would distribute. So there are two parts to the liquidator fee. One is based on the amount of realization and one is based on the amount of distribution. Now, the question which came for consideration by the regulator, that's the IBBI, whether the fee can be charged on that assets which are liquid assets. So let's say a company has cash is also an asset, bank is also an asset. So if I am having money in bank or in cash, whether that money, liquid asset, has to be realized. So the IBBI has recently, by a clarification dated 28 September, said that amounts like cash, bank, mutual funds, shares, which could be easily sold, then they are not something which you are realizing. You may distribute them, but it is not of realization of that asset. Otherwise, what will happen, and it has happened in few of the cases, wherein the liquidator took a view that even if it is a going concern and every day I am selling the stock, realizing money, this money with respect to the going concern should also be counted for the purpose of realization of my liquidator fee. So if whatever is the amount realized, percentage is applied and I would get the liquidator fee. So now this is an issue which now has been put to rest by the IBBI, and also in what few matters IBBI had held that the incorrect calculation of liquidator fee as misconduct, and also sometimes they had given warning to relevant IPs that sorry, you don't calculate like this. So ultimately, the objective of IBBI is that the liquidator should not make to the assets which he is trying to sell, realize, and distribute. So there are two aspects, realization and distribution. So clarification is on the realization part. Now, second biggest challenge in which normally we are faced with is with regard to the timeline. So it normally happens that sometimes the assets, in almost all the big matters, the assets gets attached by sometime the enforcement directorate, sometime by the tax department, and sometimes by various other authorities. Now, in such cases, when I am not able to sell or put an asset on auction because of a court order, so there could be a stay by any court. For that particular period, I have to get a specific order from Honorable Tribunal with regard to extension or exclusion, as the case may be, where I am not able to realize an asset which is not in my control because it is by a judicial or a quasi-judicial or an administrative body. In that particular case, that excluded period will be given benefit to the liquidator fee. Because the liquidator fee regulation 4 says that first 6 months and next 6 months. So first 6 months, then next 6 months, and thereafter, the fee gets reduced. So if you are able to sell the assets in first 6 months, fee is going to be the highest. If in next 6 months, so that is month 7 to 12, again the fee would be at a lesser price, lesser percentage, and then after 12 months at a lesser price. So the point is that the regulation 44, which talks about the period of liquidation, gives a tentative period of 1 year. So the idle time taken for a liquidator to dispose or to sell all the assets would be 1 year. And therefore, they have structured the fee in such a fashion that a liquidator should not try to prolong the liquidation process and try to get everything done within 12 months. However, I have seen from my personal experience, there are so many stakeholders, so many authorities, so many government departments being involved that liquidation process for a good asset heavy corporate debtor would not be possible to be closed within a year. So normally extensions are sought, but now you have to take an additional care with regard to these exclusion, that there should be a specific exclusion granted by the court, so that this particular time period wherein it was like a force majeure, not in my control, to exclude that period for the purpose of calculation of liquidator fee. Now, another aspect, and I would say it's a very, very technical aspect, that whatever fee we have to calculate, whether it would form part of the liquidation cost or not. So even the other cost which is incurred by the liquidator, which is incidental and ancillary, will definitely form part of the liquidation cost, and the amount distributed to be calculated for liquidator fee purpose only will be after deduction of this cost. Now, this is a purposive interpretation, I would say, wherein the regulator is trying to say, if you are incurring cost, you cannot get benefit on incurring cost. So a liquidator should not get enriched because he is incurring cost. In fact, they are trying to, I would say, in a way, disincentivize incurring of huge cost, because then the amount distributed to stakeholders will be more, and accordingly the percentage of the liquidator fee would be more. So this is the broad issue with regard to that clarification, and I would request all the audience professionals to read this clarification. And also one more thing, and this I have observed in most of the cases, that when you are doing liquidation, you have sold off the assets, you have took the extension, please make sure that after you are completing all the formalities of liquidation process, always file appropriate application for closure of the process. Because if once there is an order of closure, it helps you to put before the court what is the fee you have charged, what is the amount you have distributed, and you have put into knowledge of the court that yes, everything is over. Now, it could be dissolution, yes, section 54, you can very well go for dissolution read with regulation 45. But what in the case when you are selling the corporate debtor as a going concern? So if your case is of selling the CD as a going concern, even then you will have to file the closure report. So report, though the regulation 45 says that the report should be prior to dissolution, but in this particular case of selling the CD as a going concern, regulation 45 3A requires that you file a closure report. Now, this is very, very important, because the closure report will give a bird's eye view to the court. And once the closure report is filed and taken on record by the court, you are also in a way safe when you go to regulator, whenever there is an inspection or there could be any complaints, there could be any scrutiny. You are able to justify, see, whatever I have done, I have put it before the court also. So that is very, very important. This is very important. Now, another issue which is coming before the liquidator is with regard to belated claim. And I tell you, this claim issue is a very, very tricky, very sticky issue. Tricky in the sense, some of the people who have filed the claim during the process of CIRP do not file the claim during liquidation if they come to a conclusion that we are not going to get anything in the process of liquidation. Mostly, these people could be, who can be these people? These people could be operational creditors who think we are not going to get anything. And I tell you a very interesting case. In one of the matters, the company went into liquidation and there were no, I would say, tangible, crystallized, good assets in the company, except there was a factory line. Now, the factory shed, plant and machinery, everything was in a dilapidated conditions. It was just like a scrap. Now, in this particular situation, to sell this particular plant and machinery or whatever stock as a scrap, it was not going to fetch much more money. In fact, even the claim of the financial creditors could not be satisfied, and this was known to everybody. But what had happened because of the 2 years of this period, because of X or YZ litigation, after 2 years, that particular factory land, again, it was a freehold factory land in the name of the CD, it got covered under the residential limits of that particular city because the city was expanding. It came inside the city. It was near Mumbai only. This case was somewhere in Thane. So that came in the city limit, and the value of the factory land, which was very less as a factory land or a commercial industrial land, I would say, the price of this industrial land shot up as a residential property because of that city limit, it got covered. And some 30 crores was the claim of the financial creditors. But because of this coming into the city limit, and because that property now being valued as a residential property, the value of that particular anticipated project came around 100 crores. And one of the developer came with a scheme to revive the company and to pay off all the creditors. So even the financial creditors, operational creditors, government authority, all were paid, and it was a surplus of around 670 crores something. So the point is, even if a situation is where you may not get some money today because of the change of circumstances, tomorrow there could be a situation where money is available to even the creditors who never thought that they will get something. So this is very important. So seeing to all these issues, IBBI has now come out with an amendment saying that whatever claims have been submitted during CIRP have to be by default carry forward under liquidation. So if somebody is filing an updated claim, it is good. Otherwise, whatever has been filed will be considered to be deemed to be submitted under liquidation regulation. So this is very important amendment. I think I will not go on to this progress report and all. This is very simple and all of you must be aware about it. Now let us come to something which is meaty and important. That is with regard to stakeholder consultation committee. Now there has been an amendment, and I would say most of the liquidators whom I have come across, very few of them are aware that if the amendment has come, you also have to go for SCC by reconstituting SCC. So if your liquidation had been started before the amendment, even then, as per the amendment, you have to reconstitute SCC. So that reconstitution had to be done within 30 days of the commencement of the regulation. So this regulation came somewhere in September 22, 16 September to be precise. Now we are almost 1 year after, that's October 23. I have seen cases where the liquidator have taken a stand. Sir, our liquidation was before this date. It will not apply. Sorry, it will apply. A recent case, in fact, wherein the liquidator said that, sir, we have already passed a resolution for dissolution. Our dissolution application is already pending before the court. Why should I call SCC now? So court in one of the matters, and I was appearing for the liquidator, we had filed for dissolution under section 54. Court said, since there is an amendment in the regulation, all the SCC members should be invited. Whether they come or not, that's a different issue. You invite all of them. If they come, let them decide whether they want to continue with the dissolution or they have something to say. We again convened an SCC based on the amendment of the regulation. Though the same resolution got to be passed, but yes, some more people came in the SCC who were not there previously. And then it was, now the order of dissolution is also come. Point I'm trying to tell you is, even if the dissolution application is filed, sometimes some of the benches, some of the courts are having a view, because there is an amendment, please call new SCC. Another aspect of this dissolution, I will come on to the profit transaction, then I will discuss. whether a dissolution can be done or filed when already there is a avoidance transaction application pending. So that also we will discuss with the case law. Now, second important aspect. So previously, probably I'll just show you. This was the table how the representatives of a particular class had to come. So secured FC, unsecured FC, employees, government, operational creditors, all these people have to come. Number was fixed, maximum number 2, 1, 1, whatever. This particular capping of the category of the person has now been taken away. So now the law has deleted this, and the amendment says that consultation committee will be formed by all these people. That means it could be financial creditors in a class, worker employee, government department, operational creditors, who will nominate their representative. Now, this is a very, very big challenge, I tell you, is I have gone through cases where there are a number of people and they are not ready to come to a consensus of one name. So normally, and I am telling you this practice, what is done. So I have not come across any single ruling on this aspect, which clearly tells how you have to work it out. But again, as a practice, matter of practice, in different cases, what I've seen is, or what I suggest is, that whenever you are saying, let's say, employee is a category, appoint an employee and say that you are representing the complete category of employees, and try to send all the employee list persons the name of that person that he is represented. You have informed, you have taken one representative, and that's the end of the story. Now, suppose somebody comes and says, you have not included me, and I do not agree with Mr. X to represent the complete category. So then you will have to ask him that how many people you are going to represent. And he may tomorrow go in the court, and it has happened. And mostly it has happened in the case of home buyers. It has happened in the case where there are chit funds. It has happened in the case where more than one operational creditors are infighting, where they go to court and say, sir, we are not included in the SCC. And liquidator stand is, he has already taken one representative. Now, what the court will ask is that if already one person has been taken, why should we permit another person? So if that person is able to make out a case, no issues. But suppose court asks you as a liquidator, why do you not want to include him? What is the problem if he comes in the SCC? So as a liquidator, we are neutral. We can always say, yes, we have no issues. If the court is allowing him, we have no objection. As far as compliance of the regulation is concerned, we have appointed one nominee. Now, if court wants to allow anybody else, he can. We have no objection. So this is very, very important, that even if there is a one representative of a class, because the regulation does not say, if you read the regulation, it says liquidator may facilitate the stakeholders of each class, namely FC in a class, workmen in a class, employees, government department, other operational creditors, shareholders, partners, to nominate their representative for participation in consultation committee. So the issue is how they will nominate. They don't have a way of nomination. So what you will do is, you will say, we appoint Mr. X as nominee for representative of this class. Now, if somebody from that class comes and opposes, we can very well allow him also to represent that class. That is not going to be an issue. And that is what a conservative approach could be. That yes, we are allowing somebody subject to nobody opposing in the SCC. Now, whether a liquidator is required to call committee meetings every now and then, or is there any timeline? So this issue again came before regulator, that most of the liquidators were proceeding. Board came across such liquidation process where their SCC was done maybe once in a year. So the regulator said, no, there should be a healthy practice, and the SEC should be kept in loop. So now, whenever 1/3 of the members of the SEC says that you call SEC, you have to call SEC. Now, the second question which comes when the SEC has to be called and 1/3 or representatives come and say that we want an SEC, what is to be done? So in such a scenario where 33% comes and say we want to have an SEC, it is good. But as a matter of practice, as a matter of advice, I would suggest that whenever we are filing a quarterly progress report, at least one SEC should be there with respect to taking and record whatever work we have done. It could be amount, it could be litigation, it could be distribution, anything. However, one important judgment, I think it will come now. I'll come on to the judgment wherein what has to be discussed in SEC is also an issue before the insolvency board. I think this we can skip because now the word is voting. Previously, it was present and voting. So now voting has to be open for everybody, even if somebody attends the SEC or not. Now this particular issue that SEC, whatever they decide by majority, 66%, whether that advice is binding on the liquidator. So answer is no, that is not binding. But whatever is the difference of opinion of the SEC and the liquidator, now that particular has to be informed. So you see, you have to record the reason why there is a difference between your opinion and their opinion, and that has to be submitted to NCLT and to the IBBI within 5 days. So the question is very simple: whether my decision as a liquidator is coming against SEC or not. So there could be a situation where SEC decides something and I decide something. So I'll give you an example, and this is a recent order of IBBI, though it is now stayed by the Karnataka High Court on various grounds. But yes, how the regulator thinks that a liquidator should work, that is very important. So the regulation says, so if you go by the regulation 32, it talks about sale of assets. And we know how the sale of assets has to be formulated. Standalone, slum sale, collectively, going concern, all those you are already aware. Now, when we are discussing with the SEC, what we have to discuss: manner of sale, pre-bid qualification, reserve price, marketing strategy, auction process. So these are the things we have to discuss in the SEC. If we do not discuss, the view taken by the IBBI is we have not complied with the regulation 31A1B. This is very serious. They are saying if you are not discussing these 5 things in your first SEC and you are going ahead for doing an auction, sorry, that can be challenged. And they have held the liquidator to be doing an incorrect job if he is not discussing this. In this particular case, subsequently, he withdrew that notice and then did this SEC. But the point what I'm trying to reflect is that you have to make the discussion as part of your SEC meeting and have to minutize the same. And this is very important. I've seen liquidators discussing everything but not minutizing it. And this is absolutely going to go against you. You have to minutize everything what you are going to discuss. Also keep a video recording of all the SEC minutes. That's very necessary, though I'm aware that most of the people do a video recording, but still, because there has to be some evidence, some substance to countenance in case there are objections from any of the stakeholders. Second is, and as I was discussing, if the representatives from a particular class are not called upon. So normally, and this is happening every time, and in most of the cases I have seen, liquidators are of the impression that if somebody is not going to be in the COC, he will not be in the SEC also. And they go ahead in the SEC with the financial creditors only. And sometimes also only with the financial secured creditors. So again, this is absolutely incorrect. you have to discuss with everybody. If you don't, then you are violating regulation 31A. And this is what was held in this particular case. So if whatever has been discussed in SEC is not monetized, that is going to be a misconduct. Second, if you have not called all the members of the SEC as required under law, then also it is going to be a misconduct. But suppose the situation is where I am calling everybody as per regulation, but nobody is turning up, then that's a different issue. If somebody doesn't turn up for the meeting, there is no issue. I have done my job as a liquidator. If somebody comes or not, it's their headache. So these are the broader 3 parameters. Replacement, I suppose I've already discussed about the replacement. Now comes, how do you need to conduct the SEC? And this is again, most of the liquidators miss it. Same process as you do in COC, same notice, agenda, quorum, voting, recording, everything needs to be the same as applicable in the case of CIRP for the COC, because now they say it will apply mutatis mutandis in this particular liquidation process also. Now, second important aspect, and this I have seen in many cases. In fact, today only one of the matters I was appearing, wherein the question which was raised by some of the obviously workers and the employees and the shareholders of the company during the liquidation process against the liquidator was that the valuation which is done is highly unacceptable because it is done at a lower value, whereas the valuation was much more high pre-CIRP. So now, how see, we are not going to be an expert in valuer. As an IP, we may not be aware what is the exact valuation. But when you see the CIRP amendment regulation, they say that now the valuation reports also done by the creditors of the CD. So suppose there is, let's say, State Bank of India has done the valuation of the land or the building or the plant and machinery at the relevant point of time while giving term loan, while maybe giving working capital loan, whatever, stock or something, they must have valued it. That particular valuation should be taken into consideration. And now, as a liquidator and as an RP, we have a right to ask for that valuation. So this is very, very important that you get the valuation reports of the assets of the CD by the bankers. Now, there could be some cases, and I have come across such cases where there are CBI cases going against the bankers of the CD. So at the relevant point of time, there could be some allegation of corruption or bribery, wherein the even bankers are charge sheeted because they have given more money based on higher valuation of the properties which were not actually having that much value. So the genuine valuation was not there. It was a bogus valuation. So in such a similar fashion also, if there is a valuation difference, we will come to know by also going through the previous valuation report. Now, the second question which comes and which is a challenge is when a liquidator is required to go for valuation. So again, whenever I think that the valuation of the assets has changed, so just I gave you an example, the value of the property can increase with the time also. The value of the property can decrease also. Both things can happen. Land value price can increase. So again, normally, and this is I am telling you from live example, the value of the land normally we understand increases with the time because the shortage of land is happening everywhere. Can the value of land decrease? So we faced a similar situation where it was, I think, some property in Goa, one of the matters where that particular property was declared under CRZ zone. So coastal regulatory zone, it was declared. And therefore, the valuation was down because then we can only construct up to a particular height. And also we have to take care of that surrounding environment, get a clearance from CRZ authority and all those things. So even the value of property can go down based on the factors, even the value of property can go up. I gave you the example of a property situated somewhere near Thane where it was a factory industrial land and that got converted into a residential land. So such type of circumstances may arise. So point I'm trying to make is that at a relevant point of time, you can do valuation. If you are not satisfied or there is some allegation, some suggestion by some SCC members, you can also go for third valuer. Again, all this forms part of the liquidation cost only. Now, coming on to the avoidance transaction issue, and this is the most hard-hitting issue. Avoidance transaction application, as we know, and I suppose is also part of one of the study group by our IPA only with regard to this avoidance transaction. It's somewhere around 2 lakh crores is stuck in POFE transaction application. Some 700 odd applications are pending pan-India, and very few of them have been disposed in favor of the process. So whatever transactions have been identified have been reversed by the court and confirmed by the appellate court. And I think to the best of my knowledge, only one order which has went till Supreme Court and got confirmed was with regard to JP Infra, wherein 858 acres of land, which was though alleged to be a fraudulent transfer, but Supreme Court held it to be a preferential transfer, was restored back. And it was a good amount. Because 858 acres of land in NCR is a good valuation. So that much valuation increase in liquidation if the new assets come. But there are some challenges and which have come now. So the amendment says that even the avoidance transaction application can continue after the closure or the dissolution of the liquidation process, meaning thereby what they wanted to, the regulator, I would say, wanted to do was that even if the applications are pending, they could be assigned for the benefit of maybe the creditors or other stakeholders, and the right to continue them could be given to an authorized person by to, let's say, financial creditors. They would appoint somebody to continue the matter. They could be given to SRA, I would say successful bidder in the case of liquidation, or they could be given to somebody who would buy it for an amount. So basically, what we call NRRA was something which was thought of, something which was not readily realizable. We could have bought it, sold it, and thereafter closed the company. But recently, in the case of Rain Automotive, NCLT Delhi said that the regulation which allows you, that is not realizable asset, that is 37A NRRA, which permits you to sell the assets which are underlying in the PUFE application, cannot be assigned. So the fine reading of this judgment is important. Though I have given you the citation, you can very well read the complete order. I'll just try to tell you what had happened in this case. In this particular case, they were sold, let's say, it is of, let's say 1 crore is the amount. Now, suppose 1 crore is the amount which potentially the RP or the liquidator is alleging that these are fraudulent or preferential or undervalued, and it is sold, let's say, at the rate of 50,000 to somebody. Can it be permitted? So court said that whether the valuation of the PUFE transaction application or the underlying right or the asset under PUFE application can be sold for a price much lesser than what you are claiming. So they said it in negative. You cannot sell it at a throwaway price because the rights and the proceeds in the PUFE application are not crystallized. This is very, very important, that the whatever outcome is coming, that is not crystallized, therefore you cannot assign them. Second question was raised with regard to valuation of the PUFE application. So they said that in this particular case, I think it was for 26 crores and it was sold at some 50,000. So they said that, sorry, we are not going to allow you to replace the liquidator in case of this buffet application. The sale itself is illegal because valuation, crystallization of the outcome. And third, they said that once a matter is pending before the court, you cannot just assign them without waiting for the outcome. Yes, if the outcome comes, then you can definitely sell them. So if the court has said this much amount has to be restored by the, let's say, XYZ promoters, in that particular case, it could be assigned. And I think possibly the court meant that if there is an adjudication by the court, it can be sold subject to the appeals and all up till Supreme Court. So somebody who is ready to fund the litigation should get the benefit of that litigation. But they are saying that you cannot at the outset sell it off. So that is very, very important. So I would say in crux, three things. One is assignment is not possible without adjudication. Second, valuation is an important task, even if you are selling NRRA assets. Third, until the law is settled, probably the courts will not allow you to close the company, because once the company is closed, the question of continuing the application also may be under challenge, because you are a person representing the corporate debtor. And once the dissolution is done, once the person is cremated, who is going to represent that person would also be a question which probably will have to be answered. And I think an appropriate amendment in the act itself will have to be done, rather than by inserting such regulations which technically do not find any trapping in the code. So this is going to be a bigger challenge for all of us. Another aspect, and again, there is a judgment to something what is not in the law or what was not thought of. So it is regarding this schedule 1, wherein the mode of sale is given. Now you see this auction, they have said that now when you are making an auction of the corporate debtor as a going concern, if you want to sell something, you can only do it only in the first auction. So I think I'll just read it out. So the amendment says that the auction which has to be done, that is the first auction, should be done exclusively of the corporate debtor as a going concern. Now the question which comes to us is whether in subsequent auction can I go apart and do it other than going concern, or can I do going concern plus, that it means coupled with other options, that is selling it as parcel, collectively, standalone, whatever. So the question is, can I do it? So regulation 32A4 very clearly says liquidator may sell the assets of the CD under clause E of regulation 32 exclusively only at the first auction. Now, this is an interpretation issue. There are two schools of thoughts. One school of thought is, once I have done an auction and I have put it a corporate debtor as a going concern is first auction, I will not do again corporate debtor as a going concern, and then I will go on for A, B, C, D. I will not go for clause E of 32. Another school of thought is, and that is what NCLT Delhi has held in one of the matters, I think Justice Bharadwaj has held, that if you are doing first auction as a CD as a going concern, no problem. But subsequent auction, you can do corporate debtor as a going concern, but not exclusively. You can couple up it with other clauses. So in short, the second school of thought finds approval from NCLT. Now, there was a case, and I think it went up till NCLAT. NCLT Ahmedabad case, it went up till NCLAT. The question was, when there are two bidders, One has bid for corporate debtor as a going concern where the workers are going to continue. Second auction purchaser or the bidder has gone for a purchase of an asset. Now, the value which is offered by the person who has purchased only asset is more than the person who is taking the corporate debtor as a going concern. But the difference is the person who is going to take CD as a going concern will continue the worker and the labor. But the person who's going to only buy the asset will not continue the labor or the workers. And the court said that if the person who is going to continue CD as a going concern, the objective of the law gets satisfied and he should get the primacy. However, eventually, the person who offered CD as a going concern matched the bid with the person who was trying to buy only the asset. That's another flip which happened in the particular case. But yes, if you are selling CD as a going concern, courts also give you priority and preference. And therefore, if there are two bids, CD as a going concern, normally, if the matter goes to court, will be given preference, keeping in mind the objective of the code. So, objective of the code is very, very much important. So, this is something which is, I suppose, very tricky and important. Other than this, corporate debtor as a going concern, there were few judgments wherein this issue was agitated, that once I've sold the corporate debt as a going concern, whether I have to take a complete payment. So answer is you have to take payment 30 days plus 60 days. So with interest, total period is 90 days. Without interest, 30 days. So that is fixed. You cannot change the payment terms. However, in some cases where the scheme of compromise or arrangement is done, the period of 90 days gets modified according to the scheme, and that has been approved by various courts in different orders. So this 90 days period can also be rescheduled or changed to more than 90 days depending upon the consent of the creditors. Second issue is, once a CD is sold as a going concern, whether the liquidator is bound to issue sale certificate. Yes. Is it required also to execute sale deed? So the law says both of them. So there is no problem. You can do both. However, some judgments in some jurisdiction, and I am talking about states, different states, there are some judgments which says that once sale certificate is issued, it will not be liable to stamp duty. However, if sale deed is executed, it will be liable to stamp duty. So that is something which has to be obviously planned according to the state and according to the bidder. Even otherwise, whenever you are selling the asset, it is as is, where is basis. So the person who is going to buy it, it's normally the expenses are on him. So that is also one of the issues when the assets are being sold. So I think I've tried to capture as much as possible, but now I can switch on to queries. So I think Rahulji, are you there?
Yes, sir. Yes, sir. I'm there, sir.
Okay, so Rahulji, would you be taking the queries?
Yeah. So we have received a few queries from the members.
Okay.
So one of the question is whether in case of liquidation of real estate companies, unoccupied properties can be taken by home buyers.
Okay. So as you had told in the beginning also, real estate itself is the most complex case of insolvency and liquidation.
Payable with payment.
Rahulji, your voice is breaking.
I've muted it, sir.
Okay. I was just trying to tell what happens in the real estate matters. So the real estate insolvency is the most complex case, and the law has evolved to the extent that if somebody who is an allottee, so let me put it very clearly to the person who is asking the query, the law uses the word allottee. Please do not mistake it with home buyer. That is the biggest misnomer. Law says if you are an allottee under RERA, you become a financial creditor under IBC. So first thing has to be clear. The person who is an allottee under RERA becomes a financial creditor. Now, the second issue is whether that particular creditor is secured or unsecured will depend on facts of each case. So, suppose I am an allotee. When do I become an allotee? So, let's say my unit is of 1 crore rupees. I have paid 15 lakhs. So, RERA Act says if you pay 10% or more of the unit price, you become an allotee. So, if I pay 15 lakhs, I become allotee. But by paying 15 lakhs, I may become an allotee and I may also execute an agreement to sell. That does not mean I become a secured creditor. My claim will be classified as an unsecured creditor only. When do I become secured creditor? If the sale deed is done. If conveyance has been executed, I become a secured creditor. So if I am a secured creditor, then what I'm asking for? So I am asking for that unit. If that is sale deed is done, that unit is mine. So I have a right in the undivided portion of the land. Now it is possible that the land has been conveyed. The right in the property, immovable property, has been conveyed in my favor. But the construction is not complete. The amenities have not been there. So common amenities like lift, parking, club, common roads, all these things are pending. So my claim in that particular case becomes only to the extent of the amenities and the work which is not finished. But I become a secured creditor and my land, my undivided portion of land cannot be sold. Now here there is no question of unsold inventory because either I am secured or I am unsecured. If I am unsecured, then I am unsecured. I do not have any right except to the amount which might come to me under section 53 and secured creditor will be paid before me. So the only question is if I am secured, then the property belongs to me. If I am unsecured, I do not have any right except for the money which might come to me under section 53. So I suppose I have answered that query. Rahulji, we can move on to the next query. Rahulji, are you there? Rita ji,
Nipunji, Rita this side. The next question which has come is, what about pending litigations? Whether liquidation process can be completed without closure of pending cases, and if so, how?
So I think that I can answer it in two ways. One is section 33 and one is section 35. So the process of liquidation is that any litigation against the company automatically gets terminated because of 33(5). And that is what recently Honorable Supreme Court has held in the matter of Sundaresh Bhatt versus CBIC. That is very important, I would say, ratio which Chief Justice, our Honorable Chief Justice, has given, that the moratorium which is there under CIRP because of Section 14 continues under liquidation because of the deeming fiction of Section 33(5). So that is one. So any litigation against the company cannot be done, and that would be only a claim. Now question comes, litigation by the company. So if a liquidator wants to litigate, so there are two things which he has to do. One, he will have to take an approval of the professional fee for the lawyers which he has to appoint by putting it in the SCC because of the recent judgment of that 31A, amendment of 31A. Second is, if the lawyer is appointed and he is going to litigate in the court, whether the outcome is favorable or not, that should also be discussed in the SCC and taken a note. So just you appoint a lawyer and tell him to defend the case, that is not going to be the end of the story. You also have to make a cost benefit analysis and put it before SCC that whether we should fight a case against a particular litigant or not, whether we are going to fetch some money or not, because otherwise if there is a claim against us and we are also making a claim against the party, it is better that they file a claim. So Rita ji, I suppose I have answered that.
Okay. The next question is, can we share the valuation report of bankers with appointed valuers for reference?
So as such, there is no explicit provision that you can share it. But I suppose there is no prohibition also. But my view is you get an independent valuation done by the valuer and then share the report of the erstwhile bank valuer so that a comparison could be made. If you are providing him the valuation report beforehand, what will happen? He will also try to get a valuation near about that. That will never serve the purpose of the stakeholders. And there have been allegations on such type of valuation. So it is better you don't share it, you collate it, and then probably you can do a comparison.
Then there is one question, sir. What is the difference between voluntary liquidation under IBC as compared to winding up under Section 361?
So I would answer it in three parts. If I am a company and I want to close down my company, I can go for voluntary liquidation under Section 58. I can go for Section 10 under IBC, and I can also go for winding up under Section 271 of the Companies Act. Now, as far as other provisions of the winding up are concerned, they have been scrapped and everything has now been merged with the voluntary winding up, that is Section 58. So now we have only three categories limited to different aspects. 271 of Companies Act says if I am made for a specific purpose, let's say I was making some defense war tank for government of India. I got a contract and there is always a clause that you have to do exclusively this work for government of India, and after warship is being made, you have to close down the company. That is their standard clause. So the purpose of opening that company and doing the work is over. After the work is done, you can simply put a winding up and close down the company. There is no problem. Second case is I have some assets in the company. There is no liability, only assets. And let's say it's a closely held, maybe 2-partner, 3-partner company. So in that particular case, it is better to go for Section 58 and easily you have to just take an approval of the court at the end. Everything is done by the IP and there is no intervention of court as such except the closure. You have to file appropriate affidavits that the distribution is done in a particular fashion so that voluntary liquidation of corporate debtor can be done. Now, if it is an unhealthy company, that means liability is more, assets are less. In this particular situation, you have to go for Section 10. Because in that case, you will go for an unhealthy company to insolvency through the route of CIRP. Eventually, it would be liquidation and winding up. So, process would be the same. Your stage could be different depending on the facts of each case.
True. The next question is whether distribution can be made in tranches in liquidation.
So I think I have already discussed in detail with regard to the Regulation 4, which talks about realization and distribution. So the law is very clear. If I do realization and distribution in first 6 months, I am going to get the best price of my liquidator fee. If I am going to delay it, then obviously the prices reduce. So first 6 months highest, next 6 months less than that, and then beyond that it's the same, 1.88%, I think.
Okay, sir. So can liquidator authorize a person to operate the liquidation account?
Sorry, you can't do it. And IBBI has been very serious on this, and they have declared misconduct on such liquidator who have allowed somebody else to operate the bank account on behalf of the CD. As a liquidator, you become a court officer absolutely as an adjudicator. You are no longer a secretary to the COC. So sorry, you cannot allow anybody to operate liquidation account except you. However, in cases where it's a big corporate debtor, like let's say there is a company 1,000 crore, 2,000 crore going concern under liquidation, in that case probably you can appoint some CFO or somebody who is a GM finance and authorize him to, let's say, withdraw based on your calculation 5 lakh, 1 lakh per day, maybe to pay the laborers, maybe to buy expenses of day-to-day usage. That you can do, but you cannot allow liquidation account to be handled by somebody else.
Then the question is, can liquidator forfeit the EMD after sale certificate of scrap machinery has been signed and later on the buyer found out that the weight of the machinery is less than what it was stated?
So I think there are three things. One is, if you have got the complete amount, then only you will issue the sales certificate. So there comes no question of forfeiture, because once you have paid the money, only then sales certificate has to be issued. It cannot be issued before that. Second is EMD. When you are asking forfeiture, it happens when you do not pay the complete money. So suppose I have paid EMD to participate and I am declared as a successful bidder, and I do not follow the RFRP, the process document issued by the liquidator. Liquidator has all the right to forfeit it. The other party can definitely go to the court and ask. Third is, you are saying in this particular case, probably the querist is saying that the purchaser had bought it and thereafter he found that it is less in weight. So again, this is factual. You'll have to see at the time of doing due diligence and accepting the material, why did not he wait? Because all the tangible goods are allowed to be checked, verified before the material is handed over. And the process time is 90 days. You can go till 90 days to do a due diligence if it's a big chunk of stock, whatever is being purchased by the bidder.
The next question is whether distribution of assets should be done by the liquidator on the basis of security available by secured financial creditor or on the basis of claims submitted by the secured financial creditor.
So again, this is a very sticky question, and one of the matters with regard to this is pending before Honorable Supreme Court, which has not been decided till date. So that case is of Gujarat Oleo Chemicals, wherein this issue is pending before Honorable Supreme Court, wherein NCLT and NCLAT have taken a different view, both divergent view, with regard to the charges created on an asset. So one view taken is that even if whatever is the claim file, all the FCs are same, there is no concept of first charge or second charge, and every FC who is there has to be paid equally. Suppose I am a secured FC and you are also a secured FC, we both have to be treated alike. That is what the order is. Then another conflicting order is, we both are secured financial creditor, but your security is, let's say, pledge of shares. My security is of mortgage of a land. So the quality of the security should be seen as far as the security interest is concerned. But again, in fact, IBBI also in one of their discussion paper tried to discuss about it, but there is no clarity as far as law is concerned, and the issue is pending before Honorable Apex Court. Let us see what the Apex Court decides. However, mostly, and I have seen from my experience, 80-90% cases, secured creditors go by security interest only. Normally, it is the unsecured financial creditor who may have a little bit of security and try to argue that I should be paid more amount than the other secured financial creditor. So theoretically, they may be secured financial creditor, but the quality of asset which both of them possess is quite different. Only in those cases, such type of disputes are there.
Oh, okay, sir. In loss-making company under liquidation, how income tax issues will be resolved on writing off of corporate loan or any liability?
So again, this is a very tricky and typical question. As of now, I have not come across any income tax assessment of a company which is sold as a going concern in liquidation. So whatever we are discussing is only based on the legal provisions which we know. So if corporate debtor as a going concern is sold and let's say there is some loss, there have been cases where carry forward of loss is asked by the purchaser, and sometimes it was permitted in one or two cases. However, in majority of cases, now the view taken is you approach income tax authority and they will do assessment in accordance with the Income Tax Act. So in short, the answer is that income tax assessment will be done as per the Income Tax Act and the applicable provision in a particular year. Because you see every budget, there are some amendments. So recently, if you see the last budget, they said that even if you write back some loan or liability, you will have to pay the taxes. So again, how that would be dealt by this liquidation or insolvent companies, we will have to see how the courts take a view. But my view is, let's say there is 1,000 crore rupees of claim of financial creditors. Company's assets are worth only 100 crores and I buy it, let's say, for 100 crores. If I have to write back the 900 crore liability and pay tax at the rate of 30%, which is 300 crores, Why would I take a company? The objective of the IBC is to revive the company. It's not the objective to give tax to the government. It is the objective to increase the entrepreneurship and revive the company. So my view is, if there is a conflict between IBC and income tax, definitely IBC would override and would win. However, as far as benefits or concession under Income Tax Act is concerned, they may not be available in light of whatever provisions Ministry of Finance is bringing to tax, or to I would say to tax the tax loopholes. That we will have to see. As far as benefits are concerned, yes, it is discretionary.
Yes, sir. Is quarterly progress report be submitted to NCLT after we file application for dissolution with NCLT?
Yes, I always suggest you keep on filing it, because there are some compliances which you have to do. I have seen cases where the liquidation process is complete technically and a dissolution application is filed. But sometimes for one litigation or the other, sometimes PF department comes, sometimes income tax department comes, nowadays sale tax department comes, and they start objecting. So all these litigation may consume maybe a year or 2 years. In that particular time, the compliances have to be done, because there is no waiver of the compliances when the application for dissolution is pending. So my suggestion is, going by the spirit of the law, all the compliances should be done by the liquidator. So we can go on to next question, Rahul ji or Rita ma'am.
We don't have any further questions. Yeah, yes, ma'am.
Yeah, Rahulji, just now I received one question. It says, what is the liability of the IP if the transaction review audit is clean regarding PUFE, and the IP thinks there has been some preferential transfer? How should IP proceed in that case?
So what I understand from the facts is that probably there is a transaction which, according to an insolvency professional, is preferential, and probably as per the forensic auditor's opinion, it is not preferential. So the loss does not prohibit you to allow a second opinion on that particular transaction. Another aspect is, the law says that opinion has to be formed by the RP or the liquidator and not by an independent forensic auditor. Independent forensic auditor is to assist you, not to replace you. So if you have an opinion, you can definitely file it. Obviously, it should be backed by some cogent material or evidence, without which even the court will reject it. In one of the matters, I think this issue was put to rest. I think it went up till NCLAT also. It was the case of Gujarat Falls Limited, wherein they said that it's a preferential transaction, undervalued transaction. However, there was no material which could have said so, and forensic audit report was also not pointing out to such a transaction.
There is one more question, sir.
Yes, ma'am.
What are the methods? It's a general question. What are the methods of distribution of assets or sale proceedings under IBC amongst various stakeholders?
So I think that's very clear that Section 53 has to be adhered to. As far as the confusion is in this process, only I could make out this problem in financial creditors, and that too with regard to first charge holders and second charge holders, or maybe pari passu charge holders, because of this issue of Gujarat Oleo, which is pending before Honorable Apex Court. Otherwise, I don't think so. As such, there is problem of Section 53. Another issue which I can think of is of this rainbow paper, wherein the state tax department, which was ultimately returned to be an operational creditor, was held to be a secured creditor, even though it was an operational creditor. So that is something which obviously I do not agree. The ministry doesn't agree. IBBI also doesn't agree. But because there is a verdict from Honorable Apex Court, and that is the law of the land, most of the people and the liquidator and the SCC members are not distributing that much amount, which may become payable to state tax pending the review order of rainbow papers. and that has also been reserved. So I think we can expect anytime order on this particular aspect. So let us see what comes out. As of now, the view is that Rainbow paper says that state tax is to be paid equivalent, means pro rata with the financial creditors who are secured.
Okay. Sir, one more question. Whether statutory auditor of corporate debtor under CIRP or liquidation has legal or formal access to COC minutes, forensic audit reports, and various valuations?
So this is a very interesting question. Law says, as far as CIRP is concerned, valuation report is a confidential document. Even otherwise, a statutory auditor is required to only audit the books of accounts of the CD. He has no business to get into the valuation. So as far as valuation is concerned, I can tell you very clearly that it is not required to be given to the statutory auditor as far as CIRP is concerned. As far as liquidation process is concerned, if some stakeholder, as per 53, goes to the court, he can have the valuation report and asset memorandum also, which was previously prohibited. It was held previously to be confidential, but now it can be given by, obviously, when they furnish a undertaking that they will not disclose it to third party. I, in my opinion, don't think that statutory auditors should be given access to valuation report, which are confidential document. Second is COC minutes. See, who can get access to COC minute? Again, my view is because of this progress report, because of this COC minutes being filed with every IA to the court, it becomes a public document and it could be accessed by the stakeholder. But that does not mean that statutory auditor will also have a right to COC minutes, which he otherwise does not have access to as a stakeholder under Section 53. So I don't think so why he will ask for COC minutes. However, yes, he can ask for COC minutes if he is going to audit the CIRP expenses. Yes, that is ratified or not. So to that extent, yes, some extract of COC minutes can be shared. Otherwise, COC minutes is a confidential document. If you are going to share it with somebody who is not part of the process and that gets leaked and somebody takes benefit of it, then the IP would be in a difficult situation. Rita ma'am, next query.
Yes, I'm just checking, sir. What is the difference between sale of corporate debtor as going concern and sale of business of corporate debtor? Which mode is beneficial in liquidation?
Okay, so again, as I had discussed 2-3 examples, what corporate debtor would give you benefit? So I given you an example of losses. So if the CD is taken as a whole, probably the carry forward of losses would be opted subject to compliances under Income Tax Act. In fact, recently I am handling one case where there is a huge, some 2.5 crores GST credit in the CD. So even if this asset is not there in the company, this GST credit is also become an asset. So if it is sold CD, as a CD, it is sold, yes, definitely it would benefit the person who is going to buy it. Now, if somebody is interested in the business, there are some difficulties which I have seen, which are obviously the practical difficulties. Law permits to sell the business as a going concern. There is no doubt about it. Let's say a company is into the business of chemicals and also into the business of steel. There are two verticals, chemical and steel. Now, if you are interested in buying only chemical unit, you'll have to make out a balance sheet with regard to chemical business only, and you will have to sell it as a probably a parcel asset or a slum sale asset. But you will not be getting the corporate debtor. So the benefits which otherwise would have accrued as a CD will not accrue to you as a business. So that could be one of the point that you are buying a business not interested in the CD. But if I had been a choice, I would have bought a CD because according to me, that will give too many benefits, which otherwise will not be available only if I am buying a business.
Okay. Can we take one or two more questions, Nipunji?
Yes, ma'am, please. I'm at
Yeah.
your disposal.
Yes. In case of a healthy company liquidation, should intangibles be valued, which will be required by the auditors to arrive at available net worth?
As far as this process of CIRP is concerned, calculation of net worth, I don't think so, is required with regard to valuers. What is required is the identification of assets. But yes, if you're talking with respect to information memorandum and identification of assets by the IP for the purpose of making IM, yes, because we have seen companies like Videocon, where 13 companies got a common resolution plan. So one of them was only the intellectual property rights holder. So Videocon, let's say the brand was with one company, it was utilized for, let's say, electronic devices also, for mobile devices also, for XYZ purposes also. So the brand was in one company, other tangible assets were in another companies. So the point is, if there is an intangible assets like trademark, copyright, patent, industrial design, all this can be valued and identified subject to that particular thing exist. I have seen a similar case where what happened just before the CIRP, promoter was very clever and sharp. What he did was he got all the trademarks of the company assigned. So when you say assigned under Trademark Act, it is called sold all the brands to himself from the company, and company went under CIRP. Now company was manufacturing some dairy products. So that particular brand could not be used by the company until they pay a royalty to the promoter. But this was a fraudulent transfer because when the bank did the funding, they had valued these brands. And therefore, an application of Section 66 was moved that this is a fraudulent transaction. And therefore, yes, obviously, court held that this is wrong, and those particular transfers were held to be illegal. So, in such a case where the intangible assets will form or constitute the most important value of the CD, it is very important to identify them and get it valued. And if they have been fraudulently transferred to somebody else, appropriate application should be moved.
Okay. Sir, one situation has been given by a member. Situation number 1, resolution plan voting failed. Form G published again. Number 2, FC also submits a plan as now. He has the idea of value of corporate debtor. Whether FC is ineligible to submit a plan, since he has benefit of knowledge regarding the value achievable ground that is based on.
This
Yeah.
is something which I have been hearing every now and then from many IPs. So kindly understand that you are a non-biased person or maybe equivalent to a judge as far as some of the situations are concerned, where you have to be a very neutral party. A party may be at an advantage. So let's say it's an MSME. Even the promoter will have a first-hand knowledge of everything which a PRA will never have. So prospective resolution applicant will never know what is the internal worth of a company except the promoters. And law provides that a promoter can buy. Similarly, many of the cases, in fact, best of the cases, I would say, wherein asset reconstruction companies were there, NBFCs were there. In fact, Alok Industries, one of the biggest matter which Reliance took over, they made a joint venture with a asset reconstruction company and took it over. So the point is, if somebody is in the COC and just because of that he has an advantage, that will not debar him to bring a plan. He can always bring a plan, and ultimately the objective is of maximization of wealth. Objective is not that somebody is having an advantage or not. Everybody will have an advantage of their own. Like I tell you an example, if I am in an X industry and I know that this Y CD who is also in my industry will give me more value because their factory shed is near my factory shed, I will have a more value, and I know this fact. Somebody who is a third party will never have that synergy. So I will definitely buy it. So I will have an advantage. I am an operational creditor. I used to give somebody a job work basis business, and that CD has gone into IBC. I will definitely have an upper hand if that company comes to me, because I am the sole seller and buyer to the company. So it can happen like this. So there is no problem at all if somebody is in an advantageous position. Only thing is, it should not be illegal. Like somebody who is hit by 29A, they restructure their transactions like this to become eligible. Like, for example, you can read the judgment of City Securities in Reliance Naval case, wherein related party assigned their debt pending CIRP application. So pending section 7, they assigned from related to unrelated party just to become eligible to be part of COC. So in that particular case, yes, they are hit. That is something which is not permitted as held by Supreme Court in the Spade Financial Services matter. So if somebody is trying to defraud the process, somebody is trying to manage COC, somebody is trying who is disqualified to become qualified by hiding behind the layers of company, then sorry, as an RP, we have to put our foot down. But there is no problem if a COC member gives a plan. There is no problem if the promoter gives a plan. The ultimate benefit should go to stakeholders, should be voted by COC with a majority. That's all. Rita ma'am, are you there? So I think Rita ma'am, your screen is freezed.
Sir, she's just joining. Sir, I'll just talk to her. Just 1 minute, sir.
Hello.
Hello. Yes, ma'am.
Sir, am I audible now?
Yes, you are very much audible.
Okay. Actually, Rita ma'am's audio has some
Oh,
issues. Sir, the next question is, can RP seek grant or concessional loan from government for revive the company or is continuing and having potential?
I think Rahulji's voice is coming.
Rahul sir, hello. Rahul sir, actually Nipun sir is taking one
Yes,
question.
yes. Rahul.
Oh, sorry.
Yes, sorry, ma'am. Kindly repeat. Your question was RP can take a loan from government at a
Sir,
concession.
can RP seek grant or concessional loan from government for revive the company for its continuing and having potential?
So means it is the question which is asking that whether we can approach government.
Yes.
So
Loan
if
from
there is-
government for revive the company
So there
for
is
its
no
continuation.
yes, so there is no prohibition. You can approach, but the problem is what I have seen. Normally, even the public sector banks are not funding the CIRP companies. Only some people who are charging exorbitant rate of interest, they are only ready to come and fund the company during the CIRP or the liquidation process. So the reality is otherwise than what the noble thought is. But yes, you can definitely approach. If somebody is giving you money, why not? The term should be approved in the COC. That's the only thing. I think Rita ma'am is back.
Yes, sir. Actually, there was network issue. There is one more question, sir.
Yes, ma'am.
Can we get signed non-disclosure agreement with auditors for sharing confidential information?
I suggest don't share only. Why should we share the confidential information with the auditors? As I already suggested, that they are having the owners to audit books of accounts. They have nothing to get into the valuation, the process, the bidding. All these things are not the part of statutory auditor's job. So I don't think that the statutory auditors should be shared with any of the confidential information.
Okay, maybe one last question we can take. In case of going on sale, whether the loss, that benefit which is available as the shareholding will change and condition of 51% will not be satisfied.
Correct. So the resolution plan provision has already come in the Income Tax Act way back in, I think, Finance Act 2018. You have to make Principal Commissioner or Chief Commissioner of Income Tax, who is in your jurisdiction, as a party when you are claiming for such benefit in a resolution plan. So similarly, you have to also make them as a party in liquidation. If you are buying the CD as a going concern, make them as a party and ask for this concession or waiver. And normally courts give them notice and then allow it, subject to Income Tax Act provision, if at all there is some change in the figures. Or
I think, sir, we have almost covered all the questions so far received from the members. Thanks to you, Nipun sir, for taking us through this very important session on liquidation process, especially the important aspects. And you had also covered in detail the recent amendments which have been brought out in the regulations, especially in the regulations in the liquidation process. And you had patiently covered, answered all the questions which are being put forward by the members in the live session. Thanks to Rahul sir for moderating the session. And there was some network issue, so that's why some 5-10 minutes I had to just go out and come in. On behalf of the Committee on Insolvency and Bankruptcy Court, thanks indeed to both of you, sir, Nipun sir and Rahul sir, for your deliberations on this important session for the day, sir.
thank you, ma'am. Thank you very much for inviting me again. And thank you, Committee on IBC, as well as Rahul ji, for moderating the session perfectly. Thank you very much.
Thank you.
Thank you, sir.